Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Hi, I'm Kate Donnan, an associate at De Groots.
So, Kate, let's go to something really, really simple right at the very, very beginning. So, somebody's passed away and there's disputes and fights and what have you. What's the, use the word best, what are the options for resolving that?
Sure, Tony. So if you've got beneficiaries fighting over things like personal effects, so let's use an example, family photos. So it's a little bit different these days as most of our photos are digital online, but undoubtedly most of us will have experience that there's one family member that might have all the photos from years gone by that were actually printed photos. So it's not uncommon to see that there might be a dispute about what happens with those photos. I think it's very important for people to realise that where there is an estate dispute, if it does become contested and litigated and involves a court hearing, if you do get all the way to a court hearing, which is not overly common, I have to say, but we can touch on litigation later, the court's not really going to make a decision about who gets mum's original photographs and who gets the digital copies. It's really beneficial if you can come to an agreement with the other side. And I think that's one of the benefits that you can see with mediation, which is what is compulsory before going to court, because in a mediation, you can talk about things like the original photographs and come to an agreement on those types of issues. Things that the court isn't going to make a decision on, they're going to look at things with value. Not that, of course, they're not valuable, those family photos, but you sort of get where I'm going with that. So I think it's really good if you can come to an agreement with somebody else about those sort of things, because otherwise, unfortunately, you're going to rack up costs and you're going to spend a lot of time dealing with those issues when really you might just want to get on with grieving and dealing with everything else you need to deal with.
Well, that's good positive advice, not to look to litigate and go to court, just to come to a good arrangement. It can be hard, but come to a good arrangement is the best way of dealing with it.
Yes.
So we've got a very interesting question now, one that's been very, very popular, and thanks to Hollywood and all sorts of things as well. It's to do with fights over personal effects. So how is that covered in a will, and how can you possibly limit that in a will?
Sure, Tony. Again, it's one of these areas with estate administration, it's always important to remember that emotions are going to be heightened. Somebody has passed away, so you're dealing with grief on top of everything else. Throw in a fight about who gets mum's heirloom cookbook, you can imagine it's a recipe for additional stress. The one way that you can look to avoid this sort of issue is going back again, Tony, to your estate planning, making sure that you have consulted with a specialist lawyer who deals with estate planning, who's asked you the right questions. So they know what your personal effects are, they know what's important to you and what your wishes are, and they know the best way to document that. Of course, nothing is ever foolproof, and where there's a will, there's always a fight, or can be a fight, I should say. So there's a few different ways. Some people might want to list out every single thing they own and say who's getting it to seek to avoid any issues. That's probably not your best course of action. You might want to deal with certain specific things for certain people. Another way to get around it is to pick somebody that you trust to distribute things fairly. But again, that could raise its own issues. There is sometimes a preference for incorporating a list into a will, but I have to say that's not my personal preference. I like to deal with things that are very important to the person, but otherwise you do tend to just categorize that as a whole group of personal effects. I think, Tony, it's also important to think about this in the context of a blended family. So if, say, dad is living with his new partner in a house, but leaves all his personal effects to his children, what does that leave his widow with? So you need to look at all the possible scenarios. And you also need to think about the scenario where what you own when you write your will might not be what you own when you pass away. So again, it comes back to having that experienced estate planning lawyer that can ask the right questions and document it properly.
Great. Okay. So what is the meaning in a will of personal effects?
Right, so hopefully you have a definition in your will about what personal effects are. So we look otherwise to the case law about what that might be. In New South Wales, for example, there is a definition of personal effects in the Succession Act, but that's only in relation to what a spouse is entitled to if you don't leave a will. So it's basically all the things intangible personal property, unless it's used purely for business reasons, or it's coins and banknotes that aren't part of a collection, or it's things like gold bullion or uncut diamonds, which you might have to hedge against inflation. Not everybody has, but that's the terms of the legislation in New South Wales. Again, that's in relation to what a spouse is entitled to on intestacy. So it does come back to making sure that you've got that carefully crafted will that does in fact define personal effects. And that definition of personal effects does in fact fit your circumstances, because some people might want it to include everything in the house, whereas others might want to carve out specific things, such as their jewelry. They might want that separately to the rest, or they might have a collection of antique figurines or other family heirlooms that they'd like to separate out. So I suppose the short answer to your question is it depends. It depends what the will says as to what the definition of personal effects will be.
Okay. So you've got to list all the personal effects. But if you bought a boat, as an example, and it's been sitting there and you haven't put it in the will, then that makes things even more complicated.
Again, I go back to one of our favourite answers, Tony. It depends. So if you've got your will that has things like personal effects, then the way your will has been drafted, and if we look at the will as a whole and it doesn't specifically have a definition, then things like motor vehicles and boats might be included in that. So you don't have to have a will. In fact, we'd prefer you didn't have a will that lists out every single item you own. You want to make sure, as Max said, you might get 5 to 10 years out of your will. So you want to make sure that it does cover off the various things. You don't want to have to be running off to your lawyer every time you buy a new car or a boat. So you don't need to specifically name it, but depending on how your will's been drafted, it might need an update, particularly if you wouldn't want your boat to go to the person who's getting the remainder of your personal effects.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.